Good morning, everybody. Good morning, everybody. We're just going to give it a minute to let everybody who is in the waiting room join the webinar. All right. I am Lucas Weber. I'm a deputy counsel here at the Wisconsin Institute for Law and Liberty. I'm part of our litigation team. I primarily deal with our separation of powers and regulatory type lawsuits, which includes a lot of our suits against local governments, which can include some of this government transparency work. I'm going to go ahead and share my screen so you can see our presentation today. Just to let you know, at the bottom of your screen, you should be able to see, or it might be at the top now, the chat function and the Q&A function. You can ask us questions during this. I will do my best to answer those at the end. So please submit those. My colleague Eric Searing is also monitoring this, and Eric can interrupt at any time if he thinks there's a question that comes in that would be particularly timely and helpful to answer. So. Welcome. Thank you again for being here today. This is Sunshine Week. It's always a really enjoyable week. There are a lot of great organizations in Wisconsin that are working for government transparency. This week really celebrates and calls attention to the work that's being done in that area. This webinar, which we call Holding Government Accountable, is going to focus on public records requests and the open meetings statute. We're going to just try to give you a basic primer on what those statutes provide you as far as rights and what to look for, if there are issues or when you should call an attorney. So just a little bit about Will. You probably know who we are since you're on the webinar, but Will is a nonprofit law and policy center based out of Milwaukee. So we've got staff around the state of Wisconsin, but our headquarters is in downtown Milwaukee, right near City Hall. We have two kind of groups within Will. We have our litigation team, which focuses, as I said, on separation of powers, economic freedom, free speech, education freedom, our equality under the law work, and more. And then we have our policy team, which does timely, comprehensive policy research and advocacy at both the state and federal level in all of the areas that our mission supports. So education freedom, election reform, free markets, healthcare, limited government, the kind of things that Will works on every day. And if you want to learn more about our litigation team or our policy work, please check out our website at will-law.org. So on today's call, we're going to begin with public records. I'll talk about how to make a public records request and how to deal with some delays and denials. I'm going to try to give you some best practices there in dealing with public officials and public record requests. And then we're going to talk about open meetings, why they're important, what to look for, kind of how it works when we go into closed session, what that means. We'll talk a little bit about that. And again, the goal is just to give you a quick primer, an overview of all this stuff. Always a good refresher for anybody who's interested in this area. So we'll begin with the public records law. Who is covered? So state and local governments in Wisconsin are covered. Quasi-governmental entities are also covered. Quasi-governmental corporations specifically are covered. So this includes everything from paper records that they might have, in a stack on their desk to electronic records like emails, text messages, a policy, a memorandum, things like that. It's equally important, though, to understand what's not covered by the public records law. Things like drafts, draft documents, personal drafts, personal notes might not be. Personal communications unrelated to government business. So if a local official was using their email to send a note to their wife about dinner that night, that email probably is not a public record, even though it was done on an official email account. And then there are other exemptions from the statutes and case law. Things like police training videos, for example, have been found to be exempt from the public records law. And that's just because the public's right to know that information is outweighed by the perceived negative by releasing those documents. That's called the balancing test, which goes into every public records request that gets made. So when you make a public records request, the first thing you got to understand is there is no specific or required form that you have to use to make a public records request. You don't have to use any magic words. There are no strict statutory requirements for making one. You don't even have to make it in person or in writing. You could call on the phone and make a record request. Um, and as soon as the public official, the authority we call it, receives that request and can reasonably perceive that they've received that request, they have to fulfill it as soon as practicable and without delay. And what that means as soon as practicable and without delay varies depending on the nature of the request that's made. So if you make a relatively simple request, it could be very quick as the timeline they'd have to respond. If you make a pretty complicated request, they're generally going to get more leeway on that. The statute does not define how long they get. It's really just kind of a reasonableness determination given the facts of each particular situation. So we'll do some tips for effective record requests. So the first thing I always tell people when you're making a record request is just be polite. The person that you're requesting records from is a public official who probably has a lot of other duties that they're working on. And while they're required to prioritize public records, it's always a good thing to just be polite, be kind when you're requesting records. That's a good tip I always give anybody when you're dealing with anyone, but it's especially true in this area. So think about specifically what you want before you make a public records request. You should include limitations as to both the subject matter, so maybe search terms that you're looking for, and time. So you don't just want to say, I want every record forever related to some particular issue. You want to limit that as to subject matter and time to the extent you possibly can. In some cases, you might want, for example, every email from a public official for a particular day. There's that issue has been litigated before. There are some public officials who would fight that. But those are the kinds of things you want to think about before you make those public record requests. And you should consider the possible costs of making an overbroad request. So public officials can charge for the cost to locate public records if that cost is going to be $50 or more. The Attorney General has generally given the guideline that the lowest cost employee capable of conducting the search should be the one that does the locating. So if there's whoever kind of has the lowest hourly rate should be the person who's searching for those records. That's not always the case in practical reality. And then you should also consider your time in reviewing records once they're produced. If you get an overbroad request and you get a ton of records back, you're going to spend a ton of time looking through those records where you could have just been more specific on the front end to get exactly what you were looking for. And as I note, and as I said at the beginning, just treat others the way you want to be treated. The golden rule in public records is really important, and it also goes a long way. If you ever get to a point where you're in litigation, it always helps you to have been extraordinarily reasonable throughout your record request process. It will make you look very favorable if you need to go to court. Things you should not do when you are requesting a public record. Some of these seem pretty obvious. So don't ask for things you know that you're not entitled to. So certain personnel records or confidential information you're not entitled to. Try not to cast such a broad net to defeat your underlying purpose. As I said, again, you're going to be looking for too many records. It's going to be impossible for you to actually find the record you're looking for, or at least extraordinarily difficult. And you should never use a record request for an improper purpose, like trying to harass a government official or just trying to upset them or something along those lines. Best practices, it doesn't have to be a written request, as I said, but a best practice is to put it in writing, especially to put it in email, because that's the easiest way to track your request. You can, when you submit that via email, you have a record of it. It keeps it there for, presumably forever until you delete it. You want to be as specific as possible as to the dates and the search terms and which individuals you think might be in possession of the records you seek. If there is something that you specifically are looking for, um, you can always call the record custodian and say, hey, I am looking for this particular record. Can you help me? Do you know what I should be asking for? In a lot of cases, my experience is that those public officials, those record custodians are more than happy to work with you on that because in their mind, it's just going to make their life a lot easier. They're going to have to turn the records over either way. But if they know what you're looking for, they can find it a lot sooner. And then, their time is freed up and your time. You want to avoid sticker shock again, as I said. You don't want to request overbroad records. Just know that you could be charged location costs. If you are requesting hard copies, you could be charged the cost of copying those records. You are entitled to request electronic records be delivered to you electronically. So emails can be provided to you as an attachment in response there. And then one of the other best practices we always say is just ask for updates or a timeline. If you make a request and you haven't heard an acknowledgement back in about 2 weeks, you should reach out to them. Just make sure that it didn't get lost somewhere. Maybe they got 100 emails that day and this one just fell under the radar. You want to make sure that they saw it. You want to make sure you get that response, and that and that they know that you're going to keep following up. Sometimes, of course, when you make a public records request, you are going to get a delayed response. The statute says, as I mentioned earlier, that the response is as soon as practicable and without delay. So a government body or an official, they can't delay for weeks or months in acknowledging or responding to your request. They can't just delay it indefinitely. But it also doesn't mean there can't be some delay before you get a response or the records themselves. And I apologize, I have a little typo on that slide. Um, and again, it's all going to depend on the nature of your request. The best practice always for public officials is to respond as soon as they can and just say, hey, I got your request. We're working on it. Hope to have your records by X date. That's what I personally really like to see. If I see that from a public official, I know I'm dealing with somebody who knows what they're doing, and it gives me some comfort. But if you don't get that, you can ask, follow up and ask. When does that delay become unreasonable? Again, numerous factors, the scope of your request, the dates, the category of information you're being sought, how long the request has been pending. Typically, like 6 months, is about where we would primarily litigate these issues. That's sort of an internal and arbitrary deadline that we've set for ourselves. We think that's a point at which really no record request is reasonable for longer than 6 months. Um, but whether you've received any feedback at all is important. If the public official is responding to you and saying, "Hey, we're working on it. We're still working on it. We're still working on it," that's helpful for the public official. But if they're just completely ghosting you and ignoring you and not providing you with updates on it, you may want to go to court sooner. That's indicative of an unreasonable delay that you may need a judge to address. What can you do if there's a delay? The most important thing is to create that record. You want to do that in writing. You want to send an email that just says, "Hey, I'm just looking for an update on my request." Again, you want to be polite. Assume everything you put down in writing or every call that you make will be heard by a judge someday or will be read by a judge someday. Never put anything down in an email to a public official that you wouldn't want to read on the front page or that you wouldn't want your grandmother to read on the front page, is the advice I typically give to people. Again, try to work with the office to establish a timeline. If they tell you it's an overbroad request and we're working on it, just say, "Hey, maybe you can give me some of the records earlier. Maybe there's some part of this that's easier for you to get them while you work on the other stuff." You might be able to get that. Follow up periodically. If you're not receiving a response, just keep following up. But again, be polite, firm but polite. And you can ask questions about the reason for the delay. And then you could even consider narrowing your request if it looks like maybe it's going to take forever and you're able to narrow it down to a few specific records to get you started. Maybe you'd want to in those circumstances. The do nots I have here: don't expect that all government offices can respond on the same timeline or will have the same process. So state agencies typically have experienced staff who regularly respond to public records requests. I have dealt with some smaller, like town governments in Wisconsin, that frankly have never gotten a public records request or get them so rarely that they just don't know what the process is, and it takes them a little bit of time to get up to speed on it. So just kind of know what you're dealing with, and don't expect that everyone is going to have the resources and the staff knowledge that, for example, a state agency would have. And never, of course, take your frustration out on the individual that's handling the request. If there's a delay, it'll be sorted out eventually in court. You don't want to, of course, attack any of these individual public employees. So if you get denied, when you make a public records request, the public entity has really three options. They can give you the records you requested, they can give you some of the records and withhold others, or they can just deny the request outright. So in all but the first example, which is when they give you all the records, they have to provide a written explanation about the denial or the redaction or the full denial is required. So they have to explain to you why they did what they did. There are some statutory exemptions for public records, like purely personal records. As I said, for example, if somebody's emailing with their doctor or their spouse about something that's unrelated to their government work, that's purely personal. Copyright or patented information can't be distributed or requested. Published material that's for sale, like a book, if you can get it in a library, you probably can't get it through public records. Drafts, healthcare records, student records, as I said earlier, police training videos. And it all comes down to what I mentioned earlier, this public policy balancing test. So, under the public policy balancing test, when a public entity gets the record request, they will weigh what they view as the benefit of turning those records over against the cost of turning them over. So, certain law enforcement records, like confidential informants, for example, they're not going to turn those over under the balancing test because the cost of turning them over outweighs the benefit to the public of knowing who those confidential informants are. Um, what do you do then if it all comes down, you're just not getting the records you want? The final step, really the only enforcement mechanism that the public has is litigation. And the only means of litigation is what's called a petition for a writ of mandamus. A writ of mandamus is a common law writ that courts are empowered to issue that commands a public official to take action that they are required to take under the law. So, in the public records context, public officials are required to turn records over upon request. If they haven't done so, the writ of mandamus would command them to turn those records over or be subject to essentially punishment from the court. When we do this, this is always under state law, so it's state courts. So Wisconsin's public records law is different than FOIA, the federal law. Wisconsin's public records law is actually you can get a lot more records than you can under FOIA. Damages can be available here, punitive damages in some cases. If you can show, for example, that the public entity was purposefully delaying you, you may be able to get punitive damages. And there is a fee shift provision that if you go to court and you win, you can get your attorney fees paid. Now, there was this, we say recent Frame Park decision. It was from a couple years ago. This was a decision from the Supreme Court that said if you were to file a lawsuit against a public entity and that entity then turned the records over before you got a final decision from the court, that those attorney fees would not be available. So that's a decision that really cut against us in terms of public records law. And it's something that the legislature has introduced a couple of bills to try to fix over the past several sessions. And actually, just this week, circulated a new proposal supported by a number of government transparency supporting groups that would fix that decision and benefit all of us. So, one other tip that I want to give you for public records is that you can request already released records. So, public record requests themselves are public records, and so are the responses and all the records that have been turned over to somebody. One way that you can reduce costs, location costs, and get your records really quickly is to request records that were already released by the public official. This can be especially useful where somebody else has already requested those records. If there's like a particular government project that's in the news a lot lately, and for sure that this agency is getting requests from people. You can request you can just say, hey, I would like all of the open records requests you've received over the past week. And I would like a copy of all the documents you've turned over in response to public records requests from the past week. It would presumably have no location costs because it'd be very easy for the government entity just to reproduce those and send them to you. It's one way that may be helpful. Again, in those limited circumstances, you're not always going to know for sure that somebody else has requested those records, but just something that I want to get on your radar as another tool to keep in the toolbox. So that's our presentation on public records law. When it comes to open meetings are an incredibly important part of our democratic process. So whenever a government entity created by the Constitution, statute, or other law convenes for the purpose of conducting governmental business with which it is charged in a number that's sufficient to make a decision, they have to first provide notice to the public. That notice generally has to be at least 24 hours in advance. If there are particular emergency circumstances, they can truncate that time. I always give an example of, if there's like a town board that needs to convene immediately to take some action to prevent like a forest fire, they don't need to wait 24 hours while the town burns down to get together and do that. That's why the law provides some flexibility there. Some of the most common issues that we see in open meetings law would be a failure to give an adequate notice of meetings or topics that are going to be discussed in a closed session, which I'll talk about in a minute, misuse or abuse of a closed session, and failure to make a meeting reasonably accessible to all. This was something we saw a lot during kind of the COVID period, which is hard to believe it was, almost 5 years ago now. But how local governments primarily dealt with that. Just go through some examples of what would be an open meetings violation. So if you're in a village that has 7 village trustees and 5 of those 7 trustees just get together on a Friday night at one of the trustees' house and they decide to talk about a resolution that's on the agenda that's going to be before the village board, that's an open meeting violation. They can't get together and have those conversations about official business. Um, if there are 3 officials on a 6-person board, if they exchange emails agreeing to table a resolution regarding a development that requires a supermajority to go forward, that wouldn't necessarily be itself an open meetings violation because they don't have a sufficient number to conduct that business. Um, and if you have like an entire subcommittee, such as a zoning board, which show up to a common council meeting and uses the new business time to urge the council to change a zoning ordinance without prior notice or an opportunity for public comment before the zoning board, again, could be an open meetings violation. Examples here that are not open meetings violations. So this would be cases that, public officials can do this stuff. If two of the 3 town supervisors meet up at the bar to watch the Packer game, but they don't talk about official business, that's totally okay. Town supervisors are allowed to be friends with each other. They're allowed to have a beer with each other. They can get together just as long as they're not talking about official business. Administrative staff meetings within a division or units of a governmental agency are not subject to the open meetings law. Public officials who are discussing an issue over which they have no authority, like if the Board of Zoning Appeals members discusses a school board's proposed curriculum changes, not an open meetings violation. They have no authority to take action in that area, so they're not required to give notice on it. Single public officials like the mayor or a village president cannot commit an open meetings violation by themselves. And government bodies, this is an important one that we get a lot of questions on. Government bodies are not required to allow public comment. So if a government body decides they don't want to hear from the public at a particular meeting, they don't have to hear from the public. That is not an open meetings violation. Now, if they decide to limit who can speak at a hearing based on the content of what that speaker wants to say, that of course raises other First Amendment issues. But as a general matter, if a public body decides they don't want public comment at a particular meeting, they don't have to hear public comment. So notices of open meetings. As I said, generally 24 hours notice is required unless there's special circumstances like a fire or something that make that do not make that possible. The best practice, of course, is to provide the public more notice or as much notice as possible and to put it on, a website and in public places. Oftentimes it'll be in a newspaper, things like that. Notices have to be sufficient to put the public on notice as to what will be discussed at the meeting. One of the common areas that we see a lot of questions on deals with closed sessions at open meetings. So a closed session is when a government body essentially throws the public out and gets to discuss whatever they want to discuss in that closed meeting without public scrutiny. There are some high burdens that they have to meet in order to do this, though. So to hold a closed session, the body first has to provide notice that they're going to go into a closed session. They have to cite the appropriate statute. And they actually have to give a reason. They can't just say, hey, pursuant to the statute, we're going into closed session. They have to say, pursuant to the statute, we're going into closed session to discuss litigation related to X, Y, and Z. They have to be pretty specific. Now, they don't have to tell you, something that would be confidential, that would be the purpose for but they have to give you enough to know why you're going into closed session. And the public body cannot then come back into open session unless the intent to do so was previously noticed. So every public body first has to convene an open session. They would have to then make a motion to go into closed session, and that closed session has to be on the meeting notice that was previously posted. And then if they want to come back into open session after that, they have to say so before they go into closed session. Some of the reasons for closed session would be litigation or legal advice from a governmental attorney. The purpose of that closed session, of course, would be for the government body to receive advice. You wouldn't want the opposing counsel to be present at that meeting, for example, although I would love to be in all of those. That's something that they're permitted to go into closed session for. Personnel matters, determining who they're going to hire or who they may discipline or who they're going to give raises to. Those are confidential matters. They're allowed to be in closed session for that. And some bidding discussions they're allowed to be in closed session for as well. A government body may not close a session simply to protect themselves from public scrutiny during debate, right? If there's a hot button issue and one of the members says, I don't want to discuss this in public, let's discuss this in private, that's not grounds for a closed session. You have to have those debates in open session. You can't go into closed session to prevent a member of the public from recording the meeting. The public has a right to record public meetings. You can't go into closed session to hide how a body or a member of a body would vote on a particular issue. Um, Litigation, again, is the only enforcement mechanism that the public really has, although it's a little bit different under the open meetings law than it is under the open records law. So you cannot immediately go to court under an open meetings violation. The first step is you actually have to contact the district attorney or the attorney general and let them know that you believe there's an open meetings violation. Once you do that, the district attorney or the attorney general gets a 20-day window for them to first take action. They can bring a suit, and then if the district attorney or the attorney general doesn't take any action, then you as a member of the public are allowed to bring a lawsuit, and there'd be a 2-year statute of limitations on that. Again, here you can get your fees. The court may impose forfeitures or fines on those public officials who are involved. There is no damages that could be awarded here. It's considered a harm to the public at large, not to you personally. So there is no damages that the court would award in these cases. Just some practical tips, generally speaking, for holding government officials accountable. First, just know what's going on in your community. Concerns about a change to an ordinance or a curriculum, all this stuff is best addressed well before the day of the final vote. The more involved you are in the process leading up to that, the less likely there is to be some kind of issue here at the end. Litigation is always a last resort. It's never the first option. We will always make sure that all other avenues get exhausted before we would want to litigate a case. Sometimes it's really the only thing we can do, but obviously we only resort to that if we absolutely have to. Communicating your concerns with elected officials. Always remember your communications with your public officials are public records. So if you comment to something to your alderman or your state representative or state senator, those comments, those communications are all public records. Somebody can get access to those. And again, that's where the golden rule comes into play at best, right? I mean, don't say anything that you wouldn't want to read that you had said when you're on the news or something like that. And I skipped ahead there, but if you have any questions for us, you can always reach out to us anytime on this. Will, as an organization, is always happy to help point you in the right direction. While we oftentimes can't take all of these public records cases, there are a number of attorneys in the state that do take these cases, including my former colleague, Tom Kamenik at the Wisconsin Transparency Project, who is frankly one of the best in the business on this. And a lot of times we will refer these cases out to them. So with that, that's the presentation I have today, and I'm going to go ahead and stop my screen share. I've got my email on there, lucas@will-law, if anybody needs to reach out to me. You can also use our website to reach out to us. And we will dive into the Q&A if we have any questions. Eric, I don't see those anywhere.
Well, we will give it a sec yet, just so folks can gather their thoughts. But Lucas, one question for you that I think would be good to start it off is you mentioned that government can limit questions. They can limit open comment periods. So if you're going into a meeting like to your local government, if you're going to the state legislature to testify on a bill, the comments you're making should be germane to the topic at hand, correct?
Yeah, I mean yes, that's always the best practice there. Again, it depends on the nature of what the government body is doing. If they're going to hold public comment on issues that are before the board, if they're trying to, but at the same time they can't really discriminate against what you want to say because you would oppose them on something. They can't, for example, just say, we're going to take public comment from anybody who supports this proposal. And we're not going to deny, or we're going to deny it to anyone who opposes it. But yeah, that's a good point, Eric. And again, the same thing I say when dealing in writing is always good when you're in person at those public meetings. Always assume you're probably being recorded. You might be on public television when you're doing that. Being polite, making your point in a polite way is always a best practice, especially if You think maybe the issue that you're involved in with the board may someday end up in litigation. What you want to make sure you're building that record and that you're painting yourself in a very reasonable manner. It'll go a long way later on. Trust me, whatever attorney you deal with will be very happy if they see that you've been quite reasonable the whole way. It'll make their job a lot easier.
Now, Lucas, one other thing, are there different record keeping requirements for different branches of government? So, for example, like lawmakers and the executive branch, do they have a different record retention policies
They do.
when it comes to the government and who you're dealing with?
Yeah, that's actually a really great question, Eric. So they do. So state lawmakers actually have exempted themselves essentially from the record retention law. So generally speaking, public officials in Wisconsin have to retain all records. And then there is a record retention schedule that gets sent by a state board, but the default for all government is essentially you have to keep records. That's not true for the state legislature and legislative staff. They're not required to keep any records. So if you make a request to your lawmaker and they tell you I don't have any records responsive to that, they likely are telling the truth. They maybe just didn't keep those records and they have it. So that is a great question, and it's something that I don't think a lot of people understand. But if you're ever wondering why state officials, especially lawmakers, don't have records responsive to your request, it's probably because they weren't required to keep them and they didn't keep them. They got rid of the records.
But the executive branch has to hold on to those records.
Yep, they're required to hold on to those records. So any text message, for example, that any government agency employee or gubernatorial employee sends, they would have to keep records of those messages and turn those over. They're not allowed to delete those records.
Okay. And then in some instances, we've seen this in the past with some court cases, a legislator or a local official or other state official tries to circumvent the open records process by using a private email address or a third-party email address. Um, is can somebody, if they were making a proper request, would that records request apply to all appropriate records, also including their personal communications, or would it have to be specified in a specific way?
Yeah, so the short answer is yes, it includes all, even those personal communications. So if you are a public official and you have like a public email account that you conduct state business on, and then you have like a Gmail account that you sort of try to also conduct business on, but you don't think that's available, no, those Gmails are all public records to the extent you're doing state business on a Gmail account. That Gmail or your personal cell phone text messages are all subject to the public records law and would all have to be turned over. So you don't necessarily need to specifically request those. Although I will say, for what it's worth, that a lot of public officials don't know that. And so I think best practice when you're making a request is to request, make clear, I am requesting anything that may be in a personal email account or on your personal cell phone. You're requesting those records that they might have in any format that they have them. I see we just got a question coming in. If you have an agenda that simply says superintendent's report, but there's no attachment regarding what they intend to report on, is that adequate? Is there an agenda item for approval of a resolution? Well, I'll answer the first part of that is yes, that's probably adequate. Certainly if there is like a written report, that report itself would be a public record that you could get. But that's probably okay for in terms of having on an agenda. The second part of the question, if there is an agenda item for approval of a resolution and the government entity only makes the resolution available and visible in its posted agenda to members of the board, is that appropriate? I think you're running into some issues there. You'd want to make sure that the public has the ability to see that. And again, that would be a public record that you should have access to. Hopefully that answers that question. If there are any other questions that come in, I don't see any in the queue right now. I do want to thank you for joining us today. Thank you for your interest in Sunshine Week and for the important work that our group and so many others around the state are doing. Would strongly encourage you to reach out in the future if there are open records or open meetings issues, or you just want to get pointed in the right direction. You can reach out to me. You can reach out to my colleagues. You can do so on our website or send an email directly to me. I'd be more than happy to chat anytime. So with that, I think Eric, we'll go ahead and close the webinar. And thanks everybody.
Thanks, everyone.